In this lesson, we are going to learn about nature and scope of jurisprudence. What is jurisprudence? There is no universal and uniform definition of jurisprudence because law is the subject matter of jurisprudence and there is no uniform definition of law. चूँकि लॉ जो है सब्जेक्ट मैटर है jurisprudence का और चूँकि लॉ का कोई यूनिफॉर्म डेफिनेशन नहीं है इसलिए jurisprudence का भी कोई यूनिफॉर्म या यूनिवर्सल डेफिनेशन नहीं है. Another reason is people throughout the world have different opinion, ideologies and belief. Jurisprudence is very vast subject. Jurisprudence is derived from the Latin word jurisprudentia. It is made up with the two words juris plus prudentia. Juris means law and prudentia means knowledge. Hence, jurisprudence means knowledge of law. Jeremy Bentham is known as the father of the jurisprudence. He was British philosopher, jurist and social reformer. Bentham was the first who distinguished his study what is law into two parts. Law as it is expositorial approach means command of sovereign या command state का यहाँ पे होता है. Law as it ought to be सेंसोरियल अप्रोच मोरालिटी ऑफ लॉ यहाँ पे मोरालिटी ऑफ लॉ को महत्व दिया गया है. बेंथम इज रिगार्डेड एज फाउंडर ऑफ डॉक्ट्रिन ऑफ यूटिलिटेरियनिज्म. हाउ मच प्लेजर और पेन डज द लॉ ब्रिंग. मैन इज बेसिकली अ प्लेजर सीकर. यूटिलिटेरियनिज्म में क्या है कि कितना प्लेजर किसी को मिल सकता है क्योंकि मैन जो है बेसिकली अ प्लेजर सीकर है. उसको जितना ज़्यादा से ज़्यादा खुशी मिलेगी वो जो है उतना ही उसको महत्व देता है. ही वॉज ऑल्सो इन फेवर ऑफ laissez-faire विच मीन्स मिनिमम इंटरफेरेंस ऑफ लॉ इन इकोनॉमिक लाइफ ऑफ सिटीजन. जो रोज़मर्रा के इकोनॉमिक लाइफ होती है सिटीजन्स की उसमें कम से कम इंटरफेरेंस यानी कि ट्रेडिंग में और इन सब चीज़ों में काफ़ी कम इंटरफेरेंस रहता है लॉ का, तो वो laissez-faire कहलाता है. John Austin was eminent British jurist. He was professor of jurisprudence in the University of London. Austin defines jurisprudence as a philosophy of positive law. Here, positive law means command of sovereign. However, Austin favored the command of sovereign concept of Bentham, but he opposed his sensorial approach. Austin developed a theory of legal positivism. He separates moral rule from positive law. The three basic points of Austin theory of law are: the law is command issued by uncommanded commander. The sovereign यानी कि लॉ जो है इशू किया जाता है अनकमांडेड कमांडर, ऐसे शासक से जिस पर कि किसी का कोई कमांड नहीं है, यानी ताकतवर स्टेट को ताकत दी गई है यहाँ पे. इट इज़ द स्टेट विच एनफोर्सेस लॉ. कमांड्स आर बैक बाय थ्रेट्स ऑफ सैंक्शन. और ये कमांड क्या होते हैं कि ये थ्रेट ऑफ सैंक्शन यानी सैंक्शन लगाने के थ्रेट से बैकअप इनका रहता है कि अगर आप ये नहीं करोगे तो थ्रेट सैंक्शन लगा दिया जाएगा. सोवरेन इज वन हु इज हैबिचुअली ओबेड. Holland defines jurisprudence as the formal science of positive law. He defined the term positive law. He said that positive law means general rules enforced by the state. He simply added the word formal in Austin's definition. Formal here means that we only study the form and not the implementation. According to him, how positive law is applied is not the concern of jurisprudence. According to Holland, jurisprudence is not concerned with the actual material content of law but only with fundamental conceptions. Therefore, jurisprudence is formal science. It describes only external side of subject, not the internal contents. Holland is concerned only with the form and not the intricacies, यानी complexity. उसकी complexity में नहीं जाना है ज़्यादा. Salmon defined jurisprudence as the science of first principle of civil law. Jurisprudence thus deals with the particular type of law which is civil law or law of the state. He divided jurisprudence into two parts. Generic, this includes the entire body of legal doctrine. Specific, This deals with particular department or any portion of doctrine. Specific is further divided into three parts. Analytical, it deals with the content of actual legal system existing at any time, past or present. Historical, it is concerned with the legal history and its development. Ethical, according to him, the purpose of any legislation is to specify law as it ought to be. It deals with the ideal of the legal system. Julius Stone defines jurisprudence as the lawyer's extraversion. It is the lawyer's examination of the ideas and techniques of law which is derived from his knowledge of other subjects beside law, that is, his knowledge of other social sciences. जूलियस स्टोन का कहना है कि लॉयर्स का एग्जामिनेशन करता है आइडिया और टेक्निक्स का उनके कि उनकी अदर सोशल साइंसेस में क्या नॉलेज है, उसके अनुसार वो कैसे जो है लॉ को डिराइव करते हैं. In conclusion, we can safely say that jurisprudence is the study of fundamental legal principles. Scope of jurisprudence. After reading all the above mentioned definition, we would find that Austin was the only one jurist who tried to limit the scope of jurisprudence. He tried to isolate morals and theology from the study of the jurisprudence. However, the study of jurisprudence cannot be kept in certain boundaries because it includes all human conducts in the state and society. Jurisprudence is a systematic study of law and its impact on society. Wish you happy learning.
Please like this video and don't forget to subscribe this channel. It is totally free. Thank you.